familiar with CLASI. We are Community Legal Aid Society. We are a statewide nonprofit law firm. We provide free legal services for civil legal issues, and we represent some of Delaware's, more marginalized and vulnerable populations. We'll get right into the rental issue portion of the training. So there are 3 major rules of renting that you want to remember. The first one's get it in writing, the second one's put it in writing, and the third one is only the judge can put you out. So we're going to go through, from more of a generalized view of some of the protections under the Landlord-tenant Code. It doesn't cover everything. And there's always some specific code provisions that apply to specific situations. So that's why it's always good to consult with an attorney if you can. But generally, if you remember these 3 rules, you'll do a lot to protect yourselves and your rights under the code. Oh, I don't know if everyone can see me messing up there. Okay. The Landlord-tenant Code is written to, it lays out what landlord obligations are, and it lays out what tenant obligations are. Landlords are obligated, again, in a more general sense, they have to comply with all applicable provisions of any state or local code, statute, regulation, ordinance. They have to provide you with a rental unit that is safe. It can't endanger your health, welfare, or safety in any way, and it has to be, fit for the purpose for which it was rented for. So if you're to live there, then it has to be safe for you to live there. They have to keep clean and any common areas that are maintained by them, and those areas should be outlined, in your lease or at the onset of renting, what those areas are considered to be the common areas. They also have to keep it in as good as a condition as it was or ought to be by law or agreement to have been at the commencement of the tenancy, throughout. They also are obligated to maintain all electrical, plumbing, and any other facilities supplied by the landlord. They have to keep those in working order as you are renting there. Tenants have obligations as well. The first one is to pay rent under whatever your rental amount is under your lease agreement, where you pay it at and on what date. That should all be outlined in your rental agreement. Tenants are obligated not to commit waste. So, keep your unit in a good condition and not do anything in your unit that could kind of hurt or, destroy the property and that you have, the ability to control. What we talked about earlier, get it in writing, put it in writing. So you need to report in writing defective conditions. I'm not going to go in depth into conditions issues today and how to kind of handle that. But I will say, generally put it in writing. Your landlord, has a certain number of days to start working on that. And then if they don't do that, you can move forward trying to file something to get them to do that. The other thing I would say, to get in writing, if you truly have a conditions issues that a condition issue in your apartment that your landlord is ignoring, you have a right to call license and inspection to have them come to an inspection to see if the unit is in compliance, with the city or state or county's ordinances, and they will put it in writing, get you something in writing if it's not, and send that also to your landlord and start to kind of enforce their obligation to provide you with a safe rental unit. Tenants are also obligated to follow any rules and regulations of the Landlord-tenant Code, but also of your lease. So that, document, again, is really important to be reviewed so that you know what you're agreeing to and what your landlord is agreeing to. The other obligations, again, this is just straight from the code. I'm not going to go too much into all the specifics of it, but notice of extended absence. If you're going to be gone for a very long time from your rental unit, that it's a good idea to get that in writing to your landlord. Subleasing and assignments that will be outlined in your rental agreement of what's allowed and what's not allowed. Tenants are obligated to permit reasonable access to their landlord. That's to do if they want to do an inspection, if they need to fix something. So normally they have to give 48 hours notice to you if they want to enter your rental unit. However, if you have requested them to come fix something, that notice requirement, if they can give you notice requirement, they will. But obviously, if there's some conditions that urgently need to be addressed, then, they just have to be reasonable in communicating with you. You have to be reasonable with them in allowing them access to fix that. Landlords are also allowed to require a security deposit. It's a 1 month security deposit if your lease is a year or more. We're going to go into when you would have a right to early lease termination. This is something we'll also talk about later when we get into the Fair Housing Act and reasonable accommodation requests, because early lease termination might be something that might be required, for a reasonable accommodation. I'll get into what all that means later, but under the code, tenants do have a right in certain circumstances to terminate your lease early. To terminate your lease early, if you fall under one of these specific outlined circumstances, you have to provide 30 days written notice. The 30-day period begins on the first day of the month following the date of the actual notice. So if I qualified for one of these categories that we're about to talk about, and I sent my notice today on the 26th of April, that would start on May 1st. If I sent the notice on May 1st, the 30 days wouldn't start until June 1st. So one of the times the tenant may terminate their tenancy is if they die early. And so that would be could be done by the surviving spouse or personal representative of the estate. I hope that's none of us anytime soon. These other ones may or may not apply to you at some point in the future. So one is if you were in unsubsidized housing and you got accepted for admission into a rental unit that was subsidized, that is a category where you could terminate your lease early. If you were in the military and active duty and you need to move for that reason, you can terminate your lease early. If you are a victim of domestic abuse, sexual offense, or stalking, or you're seeking relief from domestic violence or abuse from any court, police agency, or domestic violence service program, you're able to provide the 30 days notice to terminate your lease early. If you have a change in the location of your employment with your present employer in an excess of 30 miles, so not that you got a new job at a new company and it's at a different location, your current job is moving you somewhere more than 30 miles away. This next category kind of is roped in with reasonable accommodations, which we will talk about later. But if there's a serious illness of the tenant or death or serious illness of a family member of the tenant's immediate family that requires a change in location of the tenant's residence on a permanent basis because of that illness, then a 30-day lease termination would be acceptable. And the last one is if you're accepted for admission to a senior citizens housing facility. The next topic I want to get into is eviction. So, you have entered a lease agreement, you have a right as a tenant to rent that rental unit, and sometimes there are conflicts, and the landlord wants to get you out and say, we're no longer in this rental agreement, I want possession. And so I think it's important for everyone to know your rights under the eviction process and what that looks like. So there are only 3 reasons a landlord can evict a tenant. The first one is the rental term is over. The second one is the tenant is behind in rent. And the third one is the tenant has breached some clause of lease. If one of those 3 things has happened, is happening, is alleged, a landlord has to go through the process we're about to go through before they legally have possession. So this is the 3rd rule of renting, only the judge can put you out. So the first step in any eviction process is the landlord has to give written notice for the reason that they would want to evict and the date that the landlord wants the tenant to leave. So this is an initial letter coming from your landlord or property management company saying, one of those three things, right? Either you didn't pay your rent and you have 5 business days to pay this rent, or we're going to say, that we have possession and we're going to file in court to make that official. The second one is you violated an important part of the lease and you have 7 days to correct this violation. If you don't do it, we're going to go to the court and try to evict based on the lease violation. And the third one is we're not renewing your lease. And this can happen at the end of your lease term, 60 days notice that they're not renewing. Or if you're on a month to month, they can give you 60 days notice at any time that they're not renewing the month to month agreement that you're under. Once you receive that notice, right, you hopefully try to correct it in the way that they're requesting. And if that doesn't happen, then your landlord will go to the court. They will file a complaint. The complaint form is an official court form that they will outline their allegations. They will attach the notice that was step one, and they will wait for the court to schedule a hearing. The complaint's going to be served on you and let you know when the hearing is. Most likely it will be posted on your door or handed to you or an adult that lives at your residence, and another copy sent in the mail. And that's going to tell you when your eviction hearing will be held. Then a hearing will be held. Both sides can explain to the judge through evidence and witnesses why, the landlord's going to say why you should be evicted. You're going to say why you shouldn't be evicted. And the judge is going to decide. If the judge decides in favor of the landlord, then that's when the landlord will be entitled to take back the property. We'll get into appeals in a minute. So if you are in subsidized housing, the written notices have some additional things that need to be included. They have to, still state the specific date the tenancy will be terminated. They have to put the reason with enough detail that you can prepare a defense. They have to say specifically, that if you remain in the unit past the termination date that they put in the notice, that they're going to seek to enforce it in court. But the kind of additional thing that needs to be in there is, so for a lot of subsidized programs, they have to advise you that you have 10 days in which to discuss the termination of your tenancy with the owner, which, we would advise that you ask for that meeting. It's just an opportunity to talk with your landlord and see if there is some way that you can work out whatever issue that they see. It also has to advise that persons with disabilities have the right to request a reasonable accommodation. There's that phrase again, that I promise we will go into more detail about to participate in the hearing process. And it has to be served, so you have to get a copy of that notice. As I said, there is the opportunity to appeal. So if there was a trial that you attended, you got that notice in the mail, you got that complaint, you saw when the hearing was, you attended your hearing, and you lose and you want a second hearing, you want that appeal hearing, you only have 5 business days to appeal. If for some reason you did not go to that first hearing, you missed it somehow, something happened, they will enter a default judgment at that hearing because you were not there to provide a defense. They're just going to take what the landlord says at face value. There's no other side provided. You have 10 calendar days to file a motion to vacate the default judgment. So if you go to a trial, 5 business days, Monday through Friday. If you somehow missed your trial, you have 10 calendar days. That includes weekends, that includes holidays. So if you lose at the first hearing and you don't appeal, or you do appeal and you lose at the second hearing, and the judge finds in favor of the landlord, that's when the landlord's entitled to take back the property. They're going to go to the court. They're going to ask for a writ of possession. They're going to take that writ of possession over to the constable's office, and that's when the constable's office will come out and provide that 24-hour eviction notice, letting you know that you got 24 hours before they change the locks. If you get that 24-hour eviction notice, take all your important papers, take all your important medications, take all your valuables, get as much out as you can, and then, they will come and change the locks the next day. Any possessions remaining in there, sorry, landlord is obligated to keep for 7 days, and provide you with reasonable access. That kind of means like one time to come back and clear out the rest of your stuff. After those 7 days, the possessions that are left in there legally can be discarded by your landlord. Now we just went, through the whole eviction process. If that whole process does not take place, now mind you, the last part of appeal or not appeal, that's up to whether one of the parties appeals or not. So there may or may not be 2 hearings, but if they don't send you a notice, send you a complaint, hold a hearing, get an order from a judge, then your landlord has illegally kicked you out. So a landlord can't change your locks, even if you haven't paid your rent. They can't, turn off water, heat, electricity, if that's something like that's in their name, in their control. They can't do something to evict you without going through these steps and getting a court order. So if they do that, you would be entitled. You'd have to file something with the court, and the court would have to, you'd have to prove the facts that they did in fact do this. You could be entitled to recover possession if you want to get back in, or terminate the rental agreement if that's what you want to do. And you also may be able to recover monetary damages that your landlord has to pay you for illegally kicking you out. So now we're going to talk about fair housing. April is Fair Housing Month. So I like to go over kind of basic up high overview of tenants' rights before going into fair housing, just because, and we'll go into it, a lot of fair housing, it's to protect people from discrimination in housing who are in certain protected classes. And it also, one of which is disability. And sometimes for people with disabilities to have equal access to use and enjoy their housing, there has to be a change in the rules. So I like to go through kind of basically, the Landlord-tenant code. So we have a basis there to then talk about fair housing, which, works in conjunction sort of with the Landlord-tenant code. So the Fair Housing Act is a federal law, and it makes it unlawful to discriminate against people in housing transactions based on certain protected classes. So the protected classes outlined by the Fair Housing Act are race, color, religion, national origin, gender, and the Fair Housing Act was recently updated. So gender also includes sexual orientation, gender identity, and all the other protected classes are disability and familial status. Familial status just means the presence of children. So you have children that you're responsible for. Also of note, national origin discrimination includes any sort of discrimination based on the language an individual speaks. Delaware also has a Fair Housing Act, which covers all of the same federally protected classes, but also has some additional protected classes. So age, that means anyone 18 and above, creed, marital status, and source of income. The one big kind of asterisk on the source of income for Delaware is if you participate in like a voucher program, a landlord does not have to participate in the voucher program. So it wouldn't be discrimination if a landlord said, I just don't participate in the Section 8 voucher program. That would not be source of income discrimination. So housing discrimination in the Act cover a wide group of kind of housing transactions. So it applies to rentals, conditions, sales, mortgage lending, homeowners insurance, advertising, anything related to living in housing, getting housing. So what types of treatment may be discriminatory? So, refusing to rent, sell, or negotiate for a house, making housing unavailable, or denying to someone that housing is available. A landlord setting different terms, conditions, or privileges for the sale or rental of housing. Also denying or making different terms or conditions for certain applicants or home seekers, but not others, based on that applicant or home seeker's protected class. Not returning phone calls of applicants when they inquire about the status of an application, and any sort of steering by a realtor or landlord, which is perpetuating patterns or promoting segregation in housing. Like they're only showing people in this protected class these apartments, and people not in that protected class these apartments or homes, things like that. So just some examples of discrimination, an ad for an apartment in the local newspaper that says no kids. Now there are some very specific carve outs for what's not covered on the act, right? So, there are certain actual senior housing facilities that can say it's just for seniors. But generally, if it's not that, then if something says no kids, that's discrimination. A Hispanic family attempting to rent a home, but it's told by the owner they won't rent to them because the neighbors don't want them living there. A tenant is evicted when the landlord finds out they have HIV or any sort of, medical condition, disability. A rental agent is told by the owner of an apartment building to deny the application of prospective tenants if they use a wheelchair. A landlord informing an African American applicant that the units are all occupied when in fact there are available units. And so a little bit later, we'll get into some of CLASI's fair housing work and how, we kind of enforce and determine if these things are happening. So there are some special issues under the Fair Housing Act, special protections for people for people with disabilities. So under the law, disability is defined as a physical or mental impairment that substantially limits one or more of a person's major life activities. So, walking, breathing, seeing, hearing, caring for yourself, just a major life activity. Someone has a condition and it impacts that major life activity. It is illegal in housing discrimination for a housing provider to fail to provide a reasonable accommodation or a reasonable modification for a person with a disability. And we're about to go into what those two terms mean. So a reasonable accommodation is a change in the rule, policy, practices, or services that are necessary for the person with a disability to have equal opportunity to use and enjoy the housing. So reasonable accommodations require you to think about discrimination in a different way. So we just kind of went over basic landlord-tenant rights. I said also, your lease really governs what the rental agreement is. Sometimes equal treatment will deny access, and it may be necessary and required by the Fair Housing Act to make reasonable changes to remove barriers. So, the difference between equality and equity, sometimes making everything equal does not truly, create an outcome where everyone is getting, the same. Equal treatment is not creating an outcome where everyone is equally able to enjoy whatever the thing may be. So when is a request unreasonable? When the accommodation that you're requesting, and when the change in the rule or policy is not related to the disability, or it would pose an undue financial and administrative hardship to the housing provider, and that's on them to come back and kind of say and prove to some extent at a certain point, or if the accommodation would fundamentally alter the nature of the program. But I will say, if you are someone with a disability and you think a change kind of in a rule, policy, or practice would help you get, equal access and enjoyment, it doesn't hurt to ask and, see what the response is. And then you can always consult an attorney if, you think their response was inappropriate. And we'll also talk about how to file fair housing complaints if you think a situation just doesn't seem right to you. So some examples of reasonable accommodations, support animals. A person's blind or has another disability who rents an apartment at a complex with a no pet policy, and they ask that the no pet policy be waived so that person can have their guide dog or other support animal. This could also include, sometimes places have a pet fee or certain pet restrictions. Like if you have a service animal that doesn't, fit into the pet restrictions, or, if you need the animal for a medical reason, asking for the pet fee to be waived, or some of the restrictions around whatever the lease says for allowable pets. If a tenant has severe asthma or another condition, and they can request a designated parking space closer to the tenant's unit. A person diagnosed with end-stage renal disease who's unable to continue to live independently, requesting early termination of the lease and waiver of the early termination fees. Again, we talked about when people may qualify for a 30-day lease termination. There may be circumstances where, due to disability, that's, a reasonable accommodation might be requesting an earlier lease termination and other kind of changing of the rules to accommodate that disability. The transfer of a person with a mobility impairment to a ground level unit. That's a reasonable accommodation. Now, if there aren't any available, it's not a requirement of the landlord to, make one available, but to have, you be the next person on the list, or if it becomes the fact that you can't, live in the unit due to disability and they don't have one available, you again could do a reasonable accommodation, maybe for an early lease termination. Reasonable modifications are different from reasonable accommodations, because a reasonable modification is a physical change in the structure of a dwelling that is necessary for a person with a disability to have equal opportunity to enjoy that housing. The thing with a reasonable modification is the modification has to be made at the expense of the person requesting the modification. So it's not up to your landlord to pay for like a ramp, handlebars, whatever other sort of modification you may need, unless that housing provider receives federal funds. So again, some examples of reasonable modifications. A wheelchair needs to have grab bars installed in the shower, installation of a ramp, possibly, widening door frames to allow wheelchair through, lowering cabinets, or altering a walkway to provide access to a public or common area. So what sort of fair housing work does CLASI do? So we, do assessment and investigation. We do education and technical assistance, direct representations of individuals who are discriminated against in housing. So clients call and let us know. And we also do testing. So we, train individuals to go out to various rental properties and, other places where housing transactions occur, and test to see, if some of the kind of discriminatory things that we talked about a little bit earlier in the training are occurring. We are recruiting testers. So if you are interested in supporting CLASI's fair housing work, please reach out to our office, and you can learn more about how to support that work. We do, pay our testers for the tests that they do. I don't know off the top of my head what the current fee is for that, but we're always looking for people who want to support our fair housing work and can go out and do some of these tests to just, again, investigate what's going on. If you are an individual and you feel like you have been discriminated against under the Fair Housing Act, if you're in one of those protected classes and you feel like a housing transaction, that you've been treated differently or denied access in some way due to that, due to being in one of those protected classes, you can, call CLASI if you want to get evaluated for assistance in a complaint. But you can also contact the Division of Human and Civil Rights. They are the Delaware Division of Human and Civil Rights. They're the state agency in Delaware. They are responsible for enforcement of both the federal and state Fair Housing Acts and the federal and state equal accommodation laws. You can file a complaint online. I included the link. Going to be hard for you to click on it via Zoom, but if you look up Division of Human and Civil Rights, they have a website. You can go, click down, file a complaint. For fair housing discrimination complaints, you have 1 year from the date that you believe you were discriminated against to file the complaint. So some resources for both any rental landlord-tenant issues you may have, or fair housing issues you may have. First of all, 211, that's kind of the catch-all. So it's the free confidential service that connects people in Delaware with various health and human service organizations. If you don't know where to go, who to call, you can start with 211, and they will help support you and find you supports. If you're looking specifically for legal services, Delaware Legal Help Link is what it's a free public service that helps people determine which legal aid provider that they should contact for the issue that they're having in Delaware. So there's 3 free legal services in Delaware. There's Community Legal Aid Society, where I work, and we're going to have the contact information for that in a minute. There's Legal Services Corporation Delaware, and there's Delaware Volunteer Legal Services. Each of the 3 offices kind of split up the civil legal issues throughout the state. So if you don't know who to call, you can go through Delaware Legal Help Link. That's what they're there for too, because they know what's all divvied up, and will send you in the right direction. That being said, if you call one agency and you were supposed to call the other, everyone will help you connect to where you need to go. So Community Legal Aid Society, very broadly, if you're thinking about housing issues, it's a little complicated. So again, I would start with Delaware Help Link, or if you call the wrong place, we'll switch you to the right place. Basically, if you live in subsidized housing for landlord-tenant issue, you call Community Legal Aid Society. If you live in non-subsidized housing, you call Legal Services Corporation Delaware. That being said, Community Legal Aid Society, CLASI, where I work, we handle fair housing cases in any type of housing, any type of fair housing case. We will evaluate you for assistance, and depending on our evaluation, can provide representation. I got through everything pretty quick. I talk pretty fast, so if anyone has questions, again, since we don't have too many people on the Zoom, if you feel comfortable, you can unmute and ask. You can put it in the chat. If you want me to go back to a slide or go back over something, I'm happy to do any of that. Okay, well, I am going to leave up the contact information. I will be here. People are welcome to jump off. That's all I have for today. But again, if anybody has any questions, I am here.